Hello and welcome to another episode of the Lexbe webinar series, your destination for sharp, timely, and practical guidance on eDiscovery, generative AI, and digital forensics. I'm Jeff Fugit, Chief Revenue Officer here at Lexbe, and I'll be your host for today's session. Generative AI continues to dominate the headlines in the innovation engine in eDiscovery. It can have an amazing impact on your cases, but also requires the appropriate checks and balances to ensure accuracy. Some early adopters have fallen prey to hallucinations and other GenAI flaws. Today we'll set the record straight and help you gain an understanding of how to utilize GenAI effectively and accurately. Today's session will be a lively conversation between Gene Albert, CEO of Lexbe, and Craig Ball, Special Master, Texas trial lawyer, computer forensic examiner, law professor, and noted authority on electronic evidence. We've got a lot to cover today, so let's dive in. Just a few quick housekeeping items before we get rolling. Our webinars happen monthly and cover leading-edge issues in eDiscovery, GenAI, and digital forensics. If you experience any technical issues, don't stress. Just shoot a note to webinars@lexbe.com and we'll jump in to help. We'll be sharing a recording and a podcast version of today's session shortly. Keep an eye on lexbe.com and on our YouTube channel. And yes, we want your questions. Pop them into the Q&A panel and we'll answer them after the presentation. Lexbe has spent 19 years helping legal teams win document-intensive litigation, and we do that with the most advanced GenAI deployment in eDiscovery. We have Lexbe Pilot, which is the next generation of early case assessment and delivers incredible case insights that get you on the right track immediately. It enables you to query the entire case. We have Lexbe Copilot, which is your GenAI-powered eDiscovery review assistant, and that's bundled in with every Lexbe hosting plan at no additional cost. And Lexbe Autopilot, automated responsiveness and privilege review, powered by GenAI. In addition, Lexbe's lightning fast. We have over 10,000 CPUs that power our platform and process over 1 million documents per hour. We had a recent client upload 1.64 terabytes of PSTs, and they were reviewing those emails the same day. We give you more time in your case documents, which results in real money in your pocket. We have a highly intuitive, user-friendly interface. We deliver the industry's fastest return on investment. We're also rated as the eDiscovery company that's the easiest to do business with, a high performer, and as having the best customer service. We also have an advanced forensic lab. We have Cellebrite and Magnet Axiom certified forensic investigators. We perform remote and on-site collections of smartphones, cloud accounts, social media, and all other sources of ESI. If you'd like a demo or a complimentary forensic consultation, email us at sales@lexbe.com. We'd love to show you how Lexbe can support your next case. And now I'll turn it over to Gene Albert and Craig Ball.
Hello, welcome everybody to this edition of the Lexbe webinar series. And I'd like to introduce Craig Ball, who, for any of our audience who's unfamiliar, Craig is a longtime friend and, in my opinion, is and has been the leading writer and speaker on legal technology topics for going on 3 decades now. Craig is also a forensic examiner, a special master or testifying expert, and specializes in matters involving complex eDiscovery. He's also an adjunct professor teaching eDiscovery at the University of Texas, Tulane Law School, and is the founder of Georgetown Law University Training Academy. Welcome, Craig. Today we're talking about your recent article, Practical Uses of AI and LLMs in Trial Practice, that you published earlier this month. And there was a related blog, a Leery Lawyer's Guide to AI. And we'll post links to the article into the blog. These materials include really step-by-step on how to get started with the LLMs and ChatGPT in particular, how to set up an account, how to properly configure security settings, and a description of various engines. So, Craig, I wanted to start off and ask, why do we need a practical guide to large language models like ChatGPT?
Thanks for that question, Gene. When I when I went looking at LLMs, and I'd been asked to talk about the topic of large language models in the practice of law for a continuing legal education program here in New Orleans not too long ago. Um, I looked around and realized that for all the hype, for all the inability to hear much of anything except about AI and large language models lately, there was a dearth of anything out there that the regular or Joe or Jane could use to get started with these things. I mean, they took the air out of the room in terms of any other topic that I'm interested in, like forensics or eDiscovery, but at the same time, did not replace it with a primer, with something that would allow mere mortals, my peers, to just do this and do it with safety. And I found that it's a bit like what most people heard about these things in the context of fear. Here is a case out of New York, say Mata Avianco, where the lawyers involved humiliated themselves by allowing large language models to put forward briefings that simply made up non-existent case citations, and then doubled down on that gross error. And I wondered to myself, would primitive man have embraced fire if the only thing you ever heard about fire was, Og got burned very badly? No, I think we'd say, I'm not touching that fire stuff. And I think that's where too many lawyers, particularly lawyers of my ilk, the gray-haired folks like you and me, heard about these stories and said, I'm not going anywhere near that. I don't want to be the poster boy or girl for bad behavior. I don't want to look ridiculous. And so I think that I wanted to write something that made it more accessible without exposing people to undue risk, showing them how to take the essential steps to both guard against unwise use of these and set these tools in ways that will make them much less prone to making your life worse rather than better, because they have the potential to make all of our lives significantly better.
Well, that's you've certainly done that, and that's a very worthy goal. And there's so much junk out there about talking about this stuff in the media and everything. It's very hard to sift through all that. I was going back for something else and looking at the adoption rate for other new technologies as they come into the legal industry, and in particular, went back and looked at when email was first came along, which is really old, and then when the cloud. That took a long time. I mean, it was years and years, before it was being used in law practices, when in hindsight, we can't imagine living without it. I think that the Zoom, by COVID came along a lot quicker, probably out of necessity. What are you, in your crystal ball? I mean, what's your thoughts about when this will be broadly adopted, into the legal industry, given the
Well,
history?
you raised two great examples, email and the cloud. Were delayed by lawyers working aggressively to spread the gospel of this is too risky for you to use in your practice.
Mm-hmm.
And of course, both of those were stampeded over. Our clients were using email, so we had to, and it was so much more efficient. And it allowed us to do so much more at such an accelerated practical rate than traditional mailed snail mail. Same thing with the cloud. We clucked our tongues as lawyers and said, "Oh, it's too risky to put your confidential data into these, things you don't control that aren't behind your firewall." And our clients and corporations blithely walked right over us and said, "We'll be there. You can join us or not as you please." I think that's clearly what is happening, and properly so, with regard to large language models. They are too powerful, too cost effective, too much fun, for lack of a better term, for us to be clucking our tongues and say, no, you can't go there. Everyone's going there. We can either choose to be there when they need us, or we can once again be arriving late at the party and left to do the cleanup.
Yeah, well, that's well said, and my certainly my experience and thoughts as well
But
with
may I
that.
add one more thing to that?
Oh,
And that
good.
is the difference here to me is that unlike a lot of technologies that came along, um, we as lawyers share something in common with large language models, these generative models, and that their currency is language. Our currency is language. And so I think the uptake for these tools will be much faster. They will be embraced with more enthusiasm because when we start looking at tools that talk, that are articulate, I think we as lawyers are much more likely to be able to recognize and embrace their power than those who are less dependent on language as the tools of their trade.
And I think we're in a better position actually to work with them than a lot of other people that aren't used to thinking through that way. Certainly in my own work and everything, I'd have a hard time going back right now. I'm very dependent on just for day-to-day stuff, and I'm just always going to it versus something else. So it's for people that haven't gotten into it, it can be a real I'd say game changer, cliche, but I mean it's just a real shift in how you think about things and how you do things.
Absolutely. The game has changed, and these tools in the right hands with the right cautions can serve to amplify our expertise, the brains we bring, the human element amplified by this technology in ways we can only now begin to imagine.
Right, and then there's just so many things you don't even really know what to even ask or how to work with it. So that now you've worked mostly with the Chat GPT, I think, and I have as well. We have as well. We experimented with the other ones and such. What's your advice? But there's just so many. There's new ones coming out. All this. What's your advice for somebody starting out on which ones to work with, or just Chat GPT for now? I mean, any thoughts on that?
Oh, I wish I could tell you of my deep analysis that resulted in my centering on ChatGPT 4. I've used Grok and DeepSeek and Perplexity and Llama and a variety of others, all the big ones, and I've played with a few of the smaller ones. For me, ChatGPT struck early enough that I could start kicking the tires. It struck the right balance between capability and affordability. I mean, I was not a year ago prepared to pay $200 a month for these tools until I begin to learn their power and learn to use them with some modest degree of skill. And so the $20 to $22 a month that one pays for ChatGPT 4, with its reasonable allocation of resources, its ability to do the assimilation of fairly large volumes of information through straightforward interfaces, have continued to make me come back to it as my familiar friend. I think it's a good way to get started, and I wrote this article around it because it's what I knew, and it's what I felt was inexpensive enough that no one could say, I'd love to try that for a month, but I'm just not going to invest that much.
Oh, totally agree, and certainly the ability. I think they've been really good on having new features and bringing them out quickly, and particularly the ability to seamlessly search onto the internet when you need it to do that. Some of the other ones have been slower to come around to that. They're getting that now. Also, for even I don't know if you've worked with the voice mode on the Chat GPT app, where you just talk back and forth to it. I mean that's whenever that gets finalized, I think that's going to completely shift things for us, and I
Blow
use
me
that
away.
whenever I can.
And especially for lawyers, that holds promise in ways that I'm not hearing people talk about. I mean, imagine, I work as an expert witness as well as counsel. But imagine being able to tell the auditory interface, be an opposing counsel. Here's my report. Now cross-examine me aggressively. It can do that.
Yes.
And that's extraordinary. The ability to ideate, to brainstorm in a voice interaction. I mean, let me say this, It's right now, it's a little bit too much of a toady. It's a little too much willing to say, you're so great. And I frankly want a little bit more constructive criticism. I want a little bit more pushback from these tools, and you have to work to get them to that point. But the ability to have a very natural conversational interface with somebody who knows just about everything is like those. It's like those cocktail party games of, if you could have dinner with anyone in the world, who would it be? Well, the fact of the matter is you can have lunch, dinner, or breakfast with ChatGPT or its ilk all day, every day, and the results of that are mind blowing. Are You just can't wait to get back in there and hear what it has to say. It's fabulous.
I mean, in many ways, it's more intelligent than 9 out of 10 of your friends, or at least my friends. So I mean, it really is amazing what it can do in some things. So
my friends may be listening, so I can't join
Yeah.
into the course. Let's just say that 9 out of 10 times it's smarter than I am, and maybe more times than that.
So hallucinations have been, the major barrier for for adoption by lawyers. Certainly, some reason to be concerned there. But what's your take on that for somebody starting out, and how should we address that issue?
Hallucinations, that is the sort of startling ability of these tools to simply make stuff up. And because they are so articulate by design, to advance these falsehoods in such a way that they seem so utterly credible, tempting lawyers and others to accept them as fact. It's kind of like as if you were to read Facebook or other social networking sites with an absolute inability to tell fact from fiction, or if in another generation you watched ads on TV and accepted everything that was said as gospel. This is a huge problem, but it is not an insurmountable problem. And the leavening force against it, the guardrail against it, is you and me and all of us who use them. And I've been telling a little story. I'm a big fan of the Godfather series of movies, which sadly my students, most of them have not seen these movies. So I've lost a key cultural touchstone in my tool belt. But at any rate, for those of you who, like me, have seen and admire these films, the second one to win the Academy Award was The Godfather 2, where Michael Corleone, the scion of the Corleone crime family, becomes the next, kingpin, the Don. And in speaking with one of his capos, his lieutenants, a fellow named Frank Pentangeli, they're talking about an alliance contemplated with a Florida-based hood named Hyman Roth. And so Michael says to Pentangeli, sort of the old school capo, he says, "My father did business with Hyman Roth." And forgive me for this bad imitation, but Pentangeli goes, he says, "Your father did business with Hyman Roth. Your father respected Hyman Roth, but your father never trusted Hyman Roth." Apologies. That's how I feel. Thank you. That's how I feel about these LLMs. I do business with them. I use them all day, and I use them to good effect. And I respect their power with the right careful usage, with the right jaundiced eye, and most importantly, bringing your own knowledge, using them in areas where you know the area, so that you can, when they speak for you and emulate your voice, that you can stand behind what they do, either through what you know as truth or what you independently verify, a huge blind spot for lawyers who have gotten in trouble. And so, yes, I don't trust them. That doesn't mean I don't use them. I mean, I trust my neighbors, but I lock my doors at night. And that's the way I am with ChatGPT. Before I have it take a blue pencil to my work work and make suggestions, particularly if those suggestions suggest a different factual basis than I am vouching for with my own experience and training and knowledge, then I am not going to put that forward until I can establish to my satisfaction that what I am adopting from ChatGPT is not what it is telling me, but what I can now vouch for due to my own independent work. And that's essential. You trust everyone, but you cut the cards. Doverai non proverai. Trust but verify, as Reagan used to say about an old Russian proverb. All of those things are essential, but most of us can recognize the power. Most of us can use these things to edit our work, to suggest questions, to cross-examine us, and so forth, and innately recognize the brilliance of what is happening and how what we're hearing is allowing us to ideate, to brainstorm, to come up with new and better variations on what we bring to the party as knowledgeable human beings.
Oh, absolutely. And one thing we think about with that is that when you are supplying it with a document or documents and you're within the context window that we'll get to a little bit, I think the chance of hallucinations on things go very, very low, if not down to zero, if you really are talking about specific documents and you're working with where if you're asking it something crazy or something creative or just something that kind of off the wall, it's going to reach further and you're going to get something different. So I think there are context differentiations with that as well.
Mm-hmm.
And then there's also the ability to set the temperature. Is that a good time to talk about that here?
Well, that or we can talk about temperature. We can talk about context window. It's however you'd like to proceed.
Let's go into the context window. I think how does what is that and how does that relate back into the hallucinations?
I've struggled with how to make people understand something, and I'm an adherent of the idea if you can't explain it to someone with an 8th grade education, maybe you don't understand it as well as you'd like. And I would be the first to confess that the whole concept of token allocations and the size of the context window can make you glaze over very quickly. In short, these tools, at least the ones that I use for the price points I employ, these tools have a limited ability of, in a sense, recalling what you've been talking about. They are limited in their ability to assimilate a large amount of textual information. That is governed by both the pricing of these, which are measured in such things called tokens that are more or less equivalent to a word or part of a long word, and context windows, which you might think about as their kind of working memory, their ability to remember what's been said before, what's been asked before, what's been introduced as a document or a prompt, a statement, or a question in the past. It begins to get stale, to forget these things as you tweak and move forward. And that becomes enormously risky, but more to me, at least, very frustrating. That as you move forward, as you begin to improve the quality of what you're getting back, it seems to get more stupid, forgive the anthropomorphization, but it seems to get more stupid, more forgetful. Suddenly your top 10 list only has 7 things on it, and it just doesn't remember. And so it's important to always keep in mind that forgetfulness, know what that context window is, and you may need to periodically refresh the prompt, reintroduce the document that was introduced many interactions ago, and refresh the memory of the electronic witness that is these tools. And so as you begin to see a degradation in the quality of its output, as you may see a tendency towards hallucinations as you discuss, or they just simply seem to become sort of stubborn and tired. Again, too much
I don't
anthropomorphizing, but
know.
something we can relate to, as they just seem to get fatigued with the topic, bored of sorts. You have to refresh. You have to almost start over. And I will periodically sometimes say to them, in a word, what question do you think you're answering here, as you would with a witness who has wandered off? Just tell me, Mr. Witness, what question do you think you're answering? Well, I will ask the LLM to summarize for me what prompt you're responding to, or in some ways tell me where you are with this, so I can then see, oh, okay, those elements of what I've asked for it, those elements of what I introduced to you, 45 minutes ago, you're not seeing that. You're not essentially electronically aware of that anymore. And I know I'm doing a disservice to listeners by humanizing these things, but I just think it's easier for us to relate. For those of you deeply steeped in the algorithms of these things, AI mavens, I'm sure you're cringing at me likening it this way, but I think it's for the rest of us. It helps to be able to think of these things interacting with us in such a human-like way, to at least have some analogies, some metaphors to human behavior that maybe help us be cautious.
Oh, and on that front, I think of it. It's a first in, first out system. So if you go beyond that context window, at least the way they're designed right now, the older stuff it's gone. There's not any logic to what it does unless you are on an interim basis summarizing and sort of bringing it forward. The
And
other
summarizing is a bit like watering down the vodka in the bar. I mean, for a while it still works, but ultimately summaries are distillations. And if everything we understood about English literature was only based on the cliff notes of the cliff notes, for anyone who even knows what that is, or for lawyers, the summary of the nutshell, you're not really doing the proper level of scholarship you need to do. You may pass the test, but you're not going to develop genuine expertise.
That very true. Let's see. Could we get on to some? You went through some wonderful examples in the paper, and I would urge everybody to go back to that. But anything that you find most compelling on what litigation uses you think are the ones that really and any litigator that with an interest in this ought to be trying out.
There's so many, and here again, I never saw anybody giving examples of prompts. Prompts are the instructions that you give to these tools along with any documents or other information you choose to ingest or upload. Prompts are what you tell it to do, what roles you tell it to play, who to be, what level of communication, how creative or how staid you want it to be. These instructions and contexts and in all of these assumptions that you want it to make in delivering its work product. And so I wasn't seeing the kinds of simple instructions of, hey, do these settings and then try this. You want a set of interrogatories in this kind of case to use in a case pending in Travis County, Texas, where you are, Gene. Well, here's an example of how you might ask for that. It's nothing perfect about it. There's nothing idealized about it, but you can fearlessly give this a try because I tested it and I'm reasonably satisfied. And then, once people learn to do the simple and develop a level of competence and confidence, they can branch out on their own. They can become a bit more adventurous. So, it will do so much. My milieu is largely discovery and forensics, so I talked a little bit about how to get it to draft interrogatories, to do preliminary responses, to give us specific objections rather than boilerplate, to develop demonstrative evidence, to help with trial prep, to perhaps listen to and critique an argument or propose an argument based on some assumptions and pleadings, to summarize depositions. I mean, one of the things these tools do masterfully, almost flawlessly, compared to those we task to do these things, are things like summarizing voluminous documents, summarizing deposition testimony, looking at a transcript in an appellate setting, suggesting some areas of attack, giving it a deposition of an expert and saying, I'm going to question this expert. Can you propose some avenues for cross-examination? Can you give me some basic questions for a deposition? There is very little we do as trial lawyers that can't be at least abetted, and in some instances, the earliest drafts can be competently put before us. Here again, I must caution at all times, anything you turn into a court, anything you put forward in a brief, anything you argue has got to be based upon your own independent confirmation of that draft work. You can't just assume it's right, but the framework that will emerge will stoke the juices, give you the ideas, help you go in the directions that you want to go. And in time, on your own would get there, but these things will get you there so much more quickly and with a level of creativity, if you choose to give it the freedom to be more creative, that will knock your socks off and at the same time, with caution, not get you into hot water. So what about jury selection? Coming up, proposing a set of voir dire questions. I'm crafting jury instructions. There's a tedious job. These things have seen in Texas, for example, the Texas pattern jury charges. You can give them examples and they can integrate the facts and the tweaks that are unique to your case and the forms and the models that you choose to share. So they are not simply a word processor filling in blanks. They can actually do a much more sophisticated job. They can create case chronologies. They can take disparate information, fairly substantial volumes of information, at least within the context of the windows and the token allocations available, they can begin to distill information into much more useful and accessible forms, spotting things on timelines, stray remarks, inconsistencies that we would, as human beings, likely get, but it would take us a lot longer and our minds wander and we come to work after having a tiff at the breakfast table and we're thinking about something else. We're fatigued. These machines don't get tired in those human ways, even though they may forget over time. So I address that in the primer and give some starting points that I think should say, try this and then tweak it your way. And then I talk about how to use the tools to be better, to teach you how to use the tools, to develop better interactions with the tools. Let the tool teach you how to speak to it in more effective ways, because the tools, are good at that. Did I miss some on the list that I should talk about?
I think, one thing I took from your paper that I tend to be conservative with it, and maybe it's an overfear of the hallucinations or something, but I always want to do to over determine it by finding the right form out of the Northern District of Texas pattern jury instructions, and then uploading that and then telling it to edit off of that or giving it a draft or something, and that probably does give you at least a more specific quality that comes out of it, and maybe has a little bit of a less of a danger of it making a real mistake. But I think I'm not really fully utilizing the tool. And I noticed with yours, on your examples, you just jump in and say, I'm in so and so court. This is what the action is about. Maybe draft it. You just give it the information, and it, as you say, it's been trained on all these publicly available legal documents and forms. So I found that as quite a liberating way of thinking about that, and I think I'm having trouble, myself, just getting up to speed on what it can do.
And everyone should move at their own comfort level, at their own pace. There are areas where I encourage creativity in, the law does not move forward without a modest amount of creativity in novel arguments and so forth. I don't want creativity in finding case support. I don't want imagined citations. I don't want quotations that aren't in the case. I don't want propositions that aren't supported. And when we talk about legal analysis, legal research, there I want to tighten it down as tight as those screws would get and bring it down to near zero in terms of a level of creativity, or what you might call temperature settings. But when, for example, I'm telling it in the verbal interface to cross-examine me as a witness, here's what I've said in my report. Here's my CV. Now, you're opposing counsel. You're aggressive. I want you to be creative and come at me and challenge what I do. I don't want it sticking to some very banal, uncreative group of questions that it may have pulled out of some manual somewhere. I want it to surprise me. I want it to come at me from left field and maybe, give me something unexpected. And that's a safe environment. That's the machine cross-examining me in private. I'm not going to get in trouble, in my thinking, letting that level of creativity go to town. Whereas there are other areas, drafting, for example, pattern jury charges, that sort of things, where there may be rules, standards, legal constructs that I want to be very clear that it is to hew closely. If I'm going to be, advocating in Texas law and I wanted to give me some suggested cases to read on point, then I want to be very clear that they need to be authorities within that district. They need to be authorities that haven't been questioned or distinguished. And then, and only then, my job is not to then rely upon those assertions. My job is then to use that as a way into my own independent legal research, using what I would call more trusted tools, whether electronic legal research, typically a Lexis or a Westlaw. And it has always been in these high-profile cases. For the most part, it has been the failure to do that independent confirmation and research, to stand behind it through that research into trusted tools, that has been responsible for these humiliating experiences.
And we, I don't know if we addressed it specifically before, but the grounding that is in the modern ones, where you can get to the sites and look at those. They didn't have that in the first versions of them, but they have that now. So there's really no reason not to be looking at those grounding. And
you're right. Increasingly, there are the tools are coming equipped with more advanced external research, with the ability to essentially put a link to the citation, so it becomes relatively straightforward to go to the reported case in a trusted setting, so that before you might adopt an argument or embrace certain language or citations, you have the ease of doing that in an efficient way. And so it becomes more and more no excuse to adopt these things without verification, to bring that "I don't trust ChatGPT" to the process. And so I can't say that enough. Everyone, whether it be the ABA or in Texas, where I'm an attorney, the rules, those who draft our rules of professional responsibility, invariably the most important takeaway from the ethical constructs is you must ensure that anything that you do with these tools is verified by your own knowledge, your own expertise, and protected against an improper use and improper circulation of confidential and privileged information. Those are the big two that you've got to remember. And both of those are not hard to do. That's the next thing. They're not hard to do. You just absolutely must remember to always do them.
And it is, I mean, and you would never do site checking with this tool. It's not designed for it.
Absolutely
I
not.
can't imagine why anyone would do that. If there's one takeaway, don't do site checking with
But
these
that's
things.
when you say this tool,
Yeah.
we don't want to throw out baby with bathwater. Increasingly, trusted resources that we do use for site checking are being enabled by the
Yes.
linguistic skills
Mhm.
of these tools. So, in the right setting, an LLM enabled research tool may be a very trustworthy place to do that. But these more general generative tools, the kind of Swiss Army knife, we can do
Mhm.
anything tools, were not purpose built to have the necessary guardrails for certain kinds of legal research and site checking. And so don't be the next front page, what's the Schadenfreude person on legal tech news
Mhm.
of look at that idiot, because there but for the grace of diligence and ethics go all of us.
Well,
And so, as I say, it's not hard to do, but it is essential to do.
well said. On the uh, we have the term prompt engineering, and as I mentioned to you before, I'm not a fan of that because I think it makes it sound, I think it scares people and makes everybody think they need to have a technical or computer background to be doing this. And these designs are, and these tools, or the generative AI is really designed for, accurate, well thought out questioning and somebody that understands language and how to use it. And I would say that we lawyers we're trained for that. I mean, we all went through first year law school. We learned how to we dealt with witnesses and stuff. So I believe that we're actually the best profession, or one of the best professions, for actually intelligently dealing with these tools, and we shouldn't be worried about it. We should be embracing it. And any comments to that claim?
Well, two things at work there. I certainly agree with you that if we don't learn to use these tools with competence and a certain level of confidence, we will be left behind in ways that we will quickly regret. These tools are such enhancements to our competitiveness, to the improving the quality of our work in small and big ways, that failing to avail ourselves of them is like saying, I don't need a mobile phone, I don't need the internet, I'm perfectly happy walking over to the county law library and pulling down the books. We all know people who are that way, but they aren't the most competitive. They aren't the people that we most want to emulate, and they are increasingly dinosaurs. So I want to come back to the point you made about prompt engineering. I don't like that title for a different reason, and that is, when I went to school as an undergraduate, I revere engineers. I went to school to become an engineer. That was my goal when I started out. And engineers in most states, I assume, certainly in Texas, that's a licensed profession. So just grabbing onto the word engineer, unless you happen to drive a train, I think that's wrong. I don't think because we've used Google, we don't call ourselves search engineers. Because we got a JD, we don't call ourselves justice engineers. And I
I call
think
myself a
prompt
doctor, though.
we're not medical engineers because I use a stethoscope. I mean, come on, folks. The people have worked hard to actually get engineering degrees. And it's a slap in the face to those who have a legal right to call themselves engineers, in my mind, to create this made up from whole cloth thing. Do what I do. I made up the term technologist, and I've called myself a forensic technologist. Nobody awarded me that degree, and I'm first to admit it's a made up title. But I didn't steal an existing title from a really well trained and licensed profession and slap it on my CV. And I don't think anyone else should either.
Got your
Respect the
soapbox.
engineers, folks.
um, one tip that you mentioned there that I think it's really important is that we lawyers, and me in particular, have a tendency to write really long sentences and try to wrap it all in there and have a lot of dependent clauses. And it sure it sure is you sure can fool that you can trip this engine up pretty easily if you make it too complex or too dependent. So I certainly from our perspective, we try to break things down unless the logic requires that. Can you comment or expand on that?
I will try, and I don't feel like I just bring some experience to it, not any deep study of this. If we were performing a mathematical equation, we know from years, most of us, I think, know that there's an order of operations that resolves what gets calculated first. And where we're unsure of that order, we tend to use, say, parentheses. And as we learn to use legal research tools, we probably learn to use Boolean constructs to be able to say the ands and the ors and use parentheses to group certain phrases and quotation marks and so forth. In human interaction, we use inflection, we use pauses, we use body language, we use a lot of subtle tools to convey the deeper meaning and the priorities in what matter to us. And I think it's easy as you begin to add a level of complexity and layer on in prompts to realize that these tools don't always have those cues available to them. And so they may, in a sense, seize on something in a prompt construct that we think is trivial or perhaps even an accident of phrasing, and in the process elevate that idea, that goal, far beyond other things that to a human reader we might understand are much more significant. These things don't think in the same way. They don't hear in the same way. They're not human. As much as we anthropomorphize them and try to speak of them as human, they aren't. And so they also aren't the computers we've grown up with. And that's another thing I need to emphasize. You put 2 and 2 plus 4 into a calculator, and if you 2 and 2 in a calculator, if you get back anything but 4, you're tossing that calculator in the garbage, or you're looking at what you entered. These tools don't work in that you put exactly the same thing in and you will get exactly the same thing out. The variability of these outputs can be a slippery slope. And so it is important, I think, to have it read back to you. Again, that sort of, tell me what question you think you're answering, Mr. Witness, as we might in deposition, to do that and see what is being prioritized, what is being left on the cutting room floor, so to speak, of these tools' formulation of the searches and the articulations that follow. Because remember, what these tools are doing is a mathematical calculation of what words should come next. Given what you've uploaded, given the prompt you've given me, given all the language that I have assimilated by scraping the web and whatever else has been fed to me, what is most likely in this context to be the next thing? Well, the in this context is what drives that process. And unless your contemplation, your formulation of the context and the order of things, what matters, what doesn't, what comes first, what comes secondarily, unless you can triage the data in the same way that the tool tends to approach it, you will be disappointed or potentially misled by the outcome. So yes, breaking things down into bytes, making sure you're checking that the things you regard as most important in the formulation don't fall off the table over time, refreshing the prompt, refreshing the upload, remembering to do these things and gaining a feel of when you need to do these things is part of the skill set that I think is essential to becoming a trusted and capable user of these tools as they emerge. It'll get better. They'll get more idiot proof. They will have better guardrails in certain iterations of these things, and they will become more specialized where you don't have to worry quite so much. In the same way that Google gives you the right answer when you ask the wrong question. I think these things will begin to be more Google-like in recognizing what you're really looking for and giving you the answer you're seeking, even if your prompts have been inartful.
Yeah, I couldn't agree more. The chain of reasoning is interesting. You know, the some of the more expensive and recent models, you know, they try to build that in themselves, but you know, there's been a lot of research. You can get better results on these ones if it is some dependent logic, instead of hoping or expecting that the ChatGPT will figure that out. You know, if you can just break that logic down into steps and have it answer one at a time, I mean, you can get more comfortable with what inference it's making, and that, you know, it's following the way you would do the logic and the same thing on whatever you're building up. So it's been
Absolutely, and many of these tools have emerged. Forgive me, I didn't mean to step on your last
Oh,
words,
no.
Gene. Many of these tools have emerged where DeepSeek, for example, where I was stunned at first at how before it got to answering the question, it sort of, you know, gave you a version of, I think what you're asking me is this, and here's how I'm going to go about answering the question. And if you have the patience to go through all of that, and not only will you learn to be more effective in prompting these tools, but you can begin to develop a certain sixth sense for how they may be going in the wrong direction or going off into the deep end. And so turning those things on and taking a moment before again, I don't mean to repeat myself and saying, okay, what is it you're going to do? What do you think you're going to do? Can you take my prompt and improve my prompt? I do that quite often. Here's what I want to do. Can you develop the prompt that will get this done? And then that is always an instructive way. I'm trying to get people started by giving them some very basic building blocks to safely kick the tires, get their feet wet on these tools. But I recognize that the next teacher you should ask for isn't me, certainly, or even perhaps a more knowledgeable human being. But once you begin interacting with these tools, having them train you. No one is better at teaching you how to use these things, and once you get started, than the tools themselves. They are very adept that way. And just saying, okay, I need to do this. Tell me how I should go about it. You may not agree, and you may not get a great answer, but you'll get something that will move you down the line in a very effective way.
Such a challenge just to get your mind around what it can do and kind of integrate that into the way you're thinking. It's you know, just it does so much now.
Indeed, it does.
Related to this was, can you talk just a bit about the role setting and the temperature control levels, and, you know, kind of how you see that in when you're using it?
Well, we touched on temperature control, and whether you're doing that either by voice commands, you know, particular wording of be creative or don't be creative, et cetera, which will have the effect of setting the temperature, or you actually give it a temperature directive, a number between 0 and 1, for example, in ChatGPT, where the very lowest numbers keep it, you know, right on the straight and narrow, which sounds like it's the way you always want to go. But honestly, I find that particularly when it is helping be an editor or giving suggestions for arguments or cross-examination, et cetera, that giving it a little bit more leeway, more license to use different phrasing, more colloquialisms and idioms, I like that, whereas other people might be terrified of that. When we talk about adopting a role, this is very important to master. I will, you know, if I'm going to have it assist me with coming up with exam questions for my law students, or helping me to grade papers or summarize things, to, you know, help me do my job better, I always want to start by saying, you know, you are me. You are a law professor teaching electronic discovery and digital evidence, or you are addressing a group of people with JDs, or you're addressing a fourth grade class. You know, the fact that you might speak in a very simplified fashion, suitable for someone with a 6th or 8th grade education doesn't mean that the output will be condescending or childish. It may just mean that what you will get back will disabuse us as lawyers prone to use sesquipedalian terminology and big words, $2
Speak for yourself,
words, and
Craig. Speak for yourself.
but I mean, big words, complex phrasing and things. Keeping it simple. Do you want to be Dickens or do you want to be Hemingway in terms of how you write and how you speak? Sometimes we want to be speaking in simple declarative sentences, using words that are in common everyday parlance, and that's crucial to our getting our message across, to being most persuasive. And so telling these tools who they are and who they are speaking to goes a long way in ensuring that our message, particularly in our role as persuaders, as advocates, will not be lost by the use of too much jargon. And certainly in my work, your work, our work in electronically stored information, it is very easy to use terms like ESI with the understanding that everybody knows that's electronically stored information and what that is, and without the recognition that very often we are speaking to mixed audiences of people that don't and will be put off by our falling back to technical or legal jargon when we can be better advocates, clearer communicators by these tools reminding us that not everybody speaks or thinks as we do.
Yeah, and it couldn't be easier to test that, with this now. One area that you had in the paper was talking about the images. I haven't worked all that much with them. It's just amazing what it does with the drawings and stuff. How do you see that as and not just the images, but just the drawing ability for trial exhibits and such? There, how do you see that being useful in somebody's practice?
First of all, so many ways, so many ways. For much of my time in the trenches, and you probably won't know this, Gene, much of my time I was speaking and traveling around teaching demonstrative evidence. That was my forte in the courtroom. I learned at the feet of some, real masters, some of them still alive, some of them gone, in Texas. Just gifted people, always pushing the envelope on reenactments and animations and ways of visually communicating. That my whole lexicon as an advocate was visual persuasion, and manifested some crude ways still with my use of PowerPoint. I think that it is going to be something that will be the rising tide that raises all boats. That people who can't draw, people who are not adept at using animation software and visual persuasion tools will find that they have gained a certain facility in being able to imagine and articulate an image they want to make a point, of being able to give it data and have it generate a compelling visual graph or something with greater facility, greater creativity, and engagement than you get by just trying to use those very simplified capabilities in something like Excel or PowerPoint. The flip side of that is, as much as it will equip us with the ability to do reenactments and visuals and the recreation of product failure modes and so many different things that have seemed beyond reach, or just simple timelines, for example, things that have been beyond reach of the most basic cases where you didn't have the budget or perhaps the time to bring in the people in that field, the gifted people to do animation, say. You'll be able to do them, literally on the night before a deposition, and that capability is empowering. The flip side, the fearsome side of that, has generally been dealt with under the rubric of deep fakes, of how are we going to preserve the integrity of evidence? How are we going to get the triers of fact, judges and jurors, to trust the real evidence we bring before them in the face of them seeing so many compelling fake things, synthesized things? How do we trust that this photograph is real and this one is not just something that somebody cooked up to fool us? That's increasingly by virtue of very compelling animations, very compelling three-dimensional and photorealistic depictions of very compelling voice synthesis, crazy stuff like that. We have to become more adept at understanding the capabilities of these tools so we can be appropriately on our guard and skilled to challenge and cross-examine when they are presented by our opponents.
And we're right on the right on the cliff on that. God knows where that's going to go. There, in the eDiscovery side, we certainly our own use of this has been that its ability to classify with a properly written prompt for responsiveness and privilege, is quite good, up at human levels for things. So our own feeling is that that's kind of at the stage of the old first level review we would do, before the attorneys got in. It can classify the ones as more and less responsive. So we certainly see a big shift as these tools get better integrated into the eDiscovery platform, so it can effectively make use of the documents without having to move them around in anything. And any comments on what you're seeing in that direction?
I think you're generous to say human-like. I honestly have come to believe that they are superhuman in the sense that they read every word. They tokenize the entire document. They don't make foolish assumptions when they see, as we do as human beings. It's been studied that only two different reviewers only agree upon the responsiveness of a document. I think the number is about 58% of the time. And so using humans is the gold standard, and it's been a topic we've talked about a lot in technology-assisted review. And I think whereas there's been an intractable reluctance from many lawyers to embrace technology-assisted review, TAR, predictive coding, to the level of engagement and penetration that had been predicted, I think that these tools are going to leapfrog and make these very familiar and really be embraced by lawyers for many reasons. They're based on basically the same DNA. I mean, TAR algorithms are based on something called tokenization and weighting, which makes them very close cousins of these LLMs in terms of tokenization of language and weighting in terms of estimating what is the next word and the word after that. In a sense, TAR is, Coco the gorilla kind of signing to us with a fairly primitive vocabulary, where, the LLMs are brilliant and articulate. I have often said that these LLMs are going to teach TAR to talk, and that's the missing link. TAR involves too much math for your average attorney, whereas language pulls us in immediately. We are masters of language, and so if TAR can talk to us, if the assessment as to responsiveness of privilege can be articulated in a language we understand, can point us to specific language in documents that form the bases for putting it in this pile or that pile, lawyers will run to use those technologies because they're quite literally, as well as metaphorically, speaking our language. Lawyers prefer words to numbers. And as a law school professor for many years, I see little changing on that score. Just because law students use more tech doesn't mean they embrace more coding or are more drawn to math. They just aren't. It's as it was when I went to law school, it is today. A lot of people end up going to become lawyers because they weren't innately good at science or math. If they were, they'd be on Wall Street making the big bucks.
Or engineering. Right.
Yes, indeed.
Well, absolutely. We've covered a lot of material here. Is there anything else you wanted to close with for our listeners, Craig, on what's been a really practical and insightful discussion?
Oh, thank you. And there's a part of me that regrets a little bit. I didn't set this up where I could have said, here, look what I put in and see what comes out. And here's the good part. Here's the part you need to check, to be a little bit more hands-on and demonstrative.
We would love to do a webinar on that, Craig, if you want to, if that was an offer.
Well, I think the best takeaway I can give you is, although you should act with caution before you take the work product of these things and retask them to the world at large, before you put them as a cite into a brief, for example, before you accept them unquestioningly, every day. There used to be an old joke about someone who kept defending themselves against a parking ticket on principle until finally they were facing the electric chair. And the punchline used to be, pay the $2, pay the $2. And so I'm kind of like, pay the $20. Even if you only do it for a month or two and you move on. The difference between trying out the free ones that maybe when you first heard about this, maybe you went and kicked the tires and you were underwhelmed, or you didn't see any way to give it a form, give it your documents, get it to work on your stuff. These tools today, the ones that you pay for, are so much more adept. Begin using them. I wouldn't write a long email nowadays where I wouldn't, paste my email in and say, can I make this tighter? Is there something I'm failing to say here that would make for a more persuasive argument? Whatever it is, proposing examples. As I say, when I give my students their every 2-week semi-weekly quizzes in my class, a very great number of those multiple choice questions nowadays are based upon me saying, here's what we covered. Here's what they read.
Mm-hmm.
Give me 10 or 12 multiple choice questions, and I'll toss out half of them as not my voice or not what I think is important. But there'll be several that I will just think are brilliant. Look for ways, set a little time aside to begin to play with these tools. And I mean play, they're fun. I have a very good friend who's a distinguished appellate practitioner, and I'm going on, forgive me,
No, please.
in Texas, very well-known appellate practitioner. And we were at her home in Breckenridge, and I sat down and I turned on the voice interaction with her and just had her start talking to ChatGPT-4. And she happens to be an expert in a particular kind of collectible pottery. And she began interacting, and I think very quickly she realized that this isn't Google. This thing is much more human-like. It is much more, for lack of a better term, insightful in synthesizing information and conversational.
And it's making inferences off of other facts that it has that nothing else has ever
right,
done.
some wrong, but always enlightening.
Mm-hmm.
Sometimes we learn from other people's mistakes, other people's misstatements. We understand that, whoa, they are not getting our argument. I need to step back and rephrase and reconsider. And so I find that the ability to talk to what is in almost every sense the smartest person in the room in a way that their time is yours and you can ask for help and get useful feedback and help. I mean, when have we really ever had that? As I said early on, we've talked at parties about who would you love to have dinner with, and the thinking behind that is the opportunity to break bread with Einstein or Helen of Troy or whoever it might be, and have them speak your language and be able to answer your questions. That's unprecedented in human experience, and it's here now. And if you aren't availing yourself of that, the people you're competing with or the people on the other side, they are or soon will be. And so find a way to enjoy it. Play with it at first, learn by doing, don't put yourself at risk. And very quickly, you will find that you're going to want to have that chat. You'll be doing something, reading something, and you'll be thinking, I can't wait to try this prompt in ChatGPT or whatever it else and see what it has to say. So just as I'm grateful, Gene, that you've reached out and asked me, what do I have to say? I think it's pretty clear that what we're doing today will not long be replaced by these kinds of interactions with LLMs. And as horrific as that may seem, being replaced by the robots, I don't really feel the need, if I'm going to the internet, to go to trial and error. I don't use Yahoo. The original Yahoo was a drilling down effort to try to find information on the web, quickly replaced by search engines. We can't even think about search on the internet without thinking about Google today. Very quickly, that will be replaced, supplanted in most respects by the integration of these large language models and generative AI tools. They will talk to us in ways that we will welcome and in ways that will benefit all of us. As long as we are careful and we never lose sight of who it is that needs to be the advocate, who it is that needs to vouch for the integrity of the information and the argument. That's us.
Very, very well said, Craig. Well, we will wrap on that. And thank you again, Craig, for joining us.
Pleasure.
And we'll see you next time. Bye-bye.
Thank you. Bye.
Thanks so much, Craig and Gene. Fantastic insights, examples, and real-world takeaways. At Lexbe, we're leading the industry with GenAI-powered eDiscovery solutions. This includes Lexbe Copilot, which is your document review and case strategy assistant. Lexbe Copilot is included in all Lexbe plans at no additional cost, so you don't have to worry about tokens or context windows or additional GenAI subscriptions. Lexbe Autopilot, which is automated document review for responsiveness and privilege. We've seen it outperform human reviewers, delivering great precision and recall scores. Plaintiff firms love this for their document-intensive cases, and in-house legal departments love it for third-party subpoenas and to help achieve litigation readiness. We price this per document with a setup fee. And then there's Lexbe Pilot, which is the next generation of early case assessment. It's incredibly powerful in equipping attorneys with a comprehensive understanding of the case and the hot documents in very short order. If you'd like a demonstration of the Lexbe eDiscovery platform and our GenAI features, simply let us know in the survey at the end of today's session or in the GoToWebinar Q&A console, and we'll get that scheduled for you. This brings us to the end of today's webinar. On behalf of the entire Lexbe team and our guest speakers, Gene Albert and Craig Ball, thank you for joining us for this webinar on the Leery Lawyer's Guide to GenAI and eDiscovery. We'll be making the following available to webinar attendees: a recorded streaming version and an MP3 podcast. And please take a moment to complete the short survey that's about to pop up. Your feedback helps us make each session better than the last. Be sure to follow Lexbe on LinkedIn so you'll be alerted to the latest podcast and webinar episodes, and watch your inbox for an invite to our next webinar on best practices in eDiscovery, GenAI, and digital forensics. Take care.